All right, so defense, you've had a chance to review the videos, the jail calls. All right, Mr. Reyes, you need to take the witness stand.
Judge, to have a motion heard on the record, however, in light of the
Oh, we can go on the record. We're on the record in the state of Texas versus Felipe Reyes. Defense, you wanted something placed on the record.
yes, Judge. Timely disclosure of the jail calls actually violates several of Felipe's constitutional rights, namely his right to a fair trial, his due process rights, and his rights to the effective assistance of counsel, because attempting to review 14 jail calls during an hour recess is not sufficient time for us to essentially change what our defensive strategy is going to be and then give our client proper legal advice. And even if we did see that these were uploaded, they were uploaded this morning. The trial started at 8 a.m., which again is not enough time to review 14 jail calls if we had gotten notice that they were uploaded this morning. And we also didn't receive an updated discovery acknowledgement till 11:39, which, if we recall, is during the time of the break. And under Hardin versus State, the court used 3 factors to determine whether the state acted in bad faith when they failed to disclose evidence. The first factor was whether the defense can show that the state intended to deceive. We believe the state knew that, or Ms. Galloway knew that she's going to use these jail calls prior to this morning, waited to upload them until this morning, and then waited to see if we would advise Felipe to take the stand, and then chose to use those jail calls against him.
All right, so here's my first question. My first question is, were these jail calls made by your client?
Yes.
And were these jail calls made over the weekend?
Yes. Friday and Saturday, which she would have had enough time to upload these prior to this morning. I think the untimely disclosure is that they waited until this morning.
All right, no, here's my question though. These were jail calls that were made over the weekend, is that correct?
Yes.
All right. Did you inform the state before 11:40 or whatever time it was? Did you inform the state you were going to call him as a witness?
Yes, we did. We
No.
prior to 11:40 this morning. Yes, we did.
No, we took a break and defense counsel informed the court and the state that they needed to approach because they needed to make a decision on whether or not your client would testify.
Judge,
Now,
he's
so here's
already testified. He's been on the stand this entire morning.
No, what I'm saying is, did the state know that your client was going to testify before today? That's either yes or no.
Yes, we said that we may call him as a witness.
No,
We said that
may.
on Friday.
Did the state know that you were going to call your client as a witness today? That's my question.
I'm sure
Not
that they
maybe.
had an inkling.
No, not a maybe. Did they know? Did you tell the state, hey, by the way, we're going to call our client as a witness today?
No, Judge.
All right, so then the question becomes, with regards to jail calls, if the jail calls were made over the weekend and the state is giving them to you today, then you have them today. And state, any other things you wish to address?
Judge, just not, I have no way of knowing whether they were going to call the defendant or not. The calls were uploaded prior to the break that we took where they stated they were unsure whether they were going to call him or not. They wanted to see something because it was smooth decision. These calls were made between the dates of 5:30-25 after we recessed from court. And so after 6:30 p.m. and then up until 6/1/2025, which was yesterday at Saturday. So I did upload them as soon as possible.
Judge,
Right.
may I respond, please? I would like to finish making my argument. So the second factor under Hardin versus State is whether the state's notice left the defense adequate time to prepare. We did talk about how we were not given adequate time to prepare because, again, we were only given an hour to review jail calls, 14 jail calls. And then the last factor is whether the state freely provided the defense with information. Arguably, I don't think that they freely provided us with the information. We, as defense counsel, only get an email when discovery is uploaded. Oftentimes that disclosure is delayed. And it would have taken a minute for them to come up to us and tell us that they were gonna use those jail calls. And then also, again, we didn't receive the updated discovery acknowledgement until 11:39 this morning.
But if you're not
Um,
calling your client as a witness, then the jail calls will not be used.
We are under no obligation to have to inform them. Under 39.14, the
that you're
state is
calling-
obligated to inform us of whenever they are gonna use evidence, which includes the state's witness
But
list.
didn't they upload the discovery? And he is
They
not,
uploaded-
obviously, your client is not on the state, did you have him on your witness list?
No, I'm.
All right, so they would not have your client on their witness list. So this is what the court is going to do. The court is going to allow the state to continue with their cross-examination. Then I will give you all a break to review any more weekend jail calls that your client is alleged to have made.
Judge, then the motion's for mistrial at this point because there is
It's
information.
denied.
And I'm just putting this on the record for appeal purposes, Judge, to protect everybody. But there is information in this that would have essentially caused us to take a different approach to our defense, including calling our client as a witness. And this was a late delay, which was bad faith by the prosecutor. And so I don't know how it's conscionable that we're proceeding with this trial when there is essential information in there that would have caused us to go a different route with our defense strategies.
Oh.
Had we known that information, we would have been able to better prepare for our defense and redirected ourselves this morning. And they've essentially prevented us from doing that, from doing our job, from being effective assistances of counsel for Felipe Reyes, because we're just getting this information now.
All right, so.
And the damage is already done by us calling him to the
So
stand.
state, any of the jail calls that you're questioning this witness about, are those jail calls that were made before the weekend?
No.
All right, so what we're gonna do, your motion for a mistrial is denied. We're gonna bring the jury back in, state you can consider, continue your cross. We'll take a recess, and defense, you can look at and review more of the DVDs if you so choose.
Judge, and then I asked that the prosecutor not be able to, or she needs to correct her statements in front of the jury, because what the call actually says in reference to her question about, is that why you called me fat? What it actually states is he is trying to talk to Miss Tammy Richardson.
That's what that is for, that is for your redirect if you should choose to do that.
I'm not gonna use that audio CD because it does, but that portion of it I think needs to be clarified, because she's misrepresenting to the jury what he actually said. What he actually said is they're trying to differentiate which female attorneys here at counsel's table he is talking about. And then
All right, so that is something for you to clear up on redirect if you so choose.
I can't clear it up without using the CD, and me using the CD opens it up to having the state using the entirety of the CD.
All right,
It's
so,
contradicting itself.
all right, so we're gonna bring the jury in.
All right, for the jury,